Alrighty guys, welcome to Unit 4 Area of Study 1. This is on the people and the Constitution. So we're going to go over the key points for this area of study to help you revise for the exam. What do you need to know about the Australian Constitution? You should be able to define the Constitution. So the Constitution is a set of rules and principles that guide the way Australia is governed. Essentially, the Constitution is a document. This document has the set of rules that establishes the nature, functions and limits of our government. Included in the Constitution are some of the following points. Firstly, the Commonwealth Parliament structure. And it says that we need to have two houses, being the Senate and the House of Representatives. That is written into our Constitution. Our Commonwealth Parliament must run as a bicameral parliament. Also included in the Constitution is point 2. The High Court is established. Before the Constitution, we didn't have a High Court, and the High Court's powers are also outlined in the Constitution. There are also specific powers outlined for the Commonwealth Parliament. These are also known as exclusive powers. And also outlined are the shared powers between the state and the Commonwealth, known as concurrent powers. Also included in our Constitution is the division of lawmaking powers, that we would have a separate legislative, judicial and executive arms of lawmaking. Finally, the other thing you need to know about the Constitution is written into it is how the Constitution can be changed. And we know that this is by referendum. Some of the key terms and definitions you'll need to know and use in your responses include Constitution, which we've already gone through, Parliament. Now, Parliament and government are two different terms. Parliament is a formal assembly of representatives of the people that are elected by the Australian people that gather together to make the laws. So everybody who has a seat in Parliament is Parliament. The government is different. The government means the people with the party with the most seats, who are the leaders of the country. So Parliament is a term for the broader group. Government is a term for the group in power. So please make sure you're using them right and not interchangeably. You'll also need to know, obviously, the lower house is the House of Representatives and the Senate is the upper house. As stated before, you will need to know the structure of the Commonwealth Parliament, meaning the Australian, or sometimes referred to as Federal Parliament. VCA may interchange those terms, so make sure you are aware of what the question is asking you. If we are looking at the Commonwealth Parliament, let's start from the bottom. We have our lower house, the House of Representatives, who has some main roles. Firstly, to initiate legislation, but also to represent the people. We then have the upper house, the Senate, which acts as a house of review, but also acts as a state's house, representing the interests of each of our states. Lastly, at the top of our parliamentary system is the Governor-General, who acts as the Queen's representative. It is their job to grant royal assent to legislation. It is also part of their role to appoint the Executive Council. You should be able to outline in detail each of those points. I strongly suggest going back through your textbook and being able to elaborate on each of those points. Here are some key terms that you will need to be able to work effectively and answer questions on this area of study. Government. This is the political that holds the most seats in the lower house of Parliament. They form the ruling party and have authority to govern. I cannot stress enough that on the trial exam, we didn't really use these terms correctly. It's important that you know the difference between government, Parliament, and how government is formed. The government is formed when we have an election, and the people in the House of Representatives are elected in. They all belong potentially to a party, and whichever party has the most seats forms the government of the day. In the lower house, please try to get that right. You also have the cabinet. The cabinet are the policy making group made up of the Premier, if we're talking about the Victorian government, but also his senior government ministers. So your Minister of Health, your Minister for Education. Cabinet are basically the PM's best mates, who are the ones who help him with law. So they are very influential. Lastly, we have the opposition. This is the party with the second largest number of seats. So say, for instance, Liberals in power at the moment, Labor would be the opposition party. It is their role to question, scrutinise and hold the government responsible. Even though they are not currently in power, it is still an important role to fulfil. Then we have the Victorian Parliament. It may also be referred to as state parliament in the VCAR exam. You again will need to know the different structure and the roles for each of those houses in more detail than what is listed here. The lower house is the Legislative Assembly. The upper house is the Legislative Assembly, and we have the Governor. You can see the roles there are slightly different, so you can't just memorise the exact same for Commonwealth Parliament and Victorian Parliament. While the lower house, the Legislative Assembly, does initiate legislation, much like its Commonwealth counterpart, instead of saying it's the People's House, another thing that you can say is that it provides a representative government. Same with the Legislative Council. We wouldn't call it a State's House. Instead, we would say one of the other roles is to scrutinise bills. And same with the Governor and their role. While granting royal assent is still the same, they appoint an Executive Council. All of those key terms are a little bit different to what you saw on the previous slide. So it's important you read the question carefully and then you answer it correctly. Study, you'll also need to know about the division of lawmaking powers. Now, you're confused with separation of power, so make sure that you are again answering the question correctly. Division of lawmaking powers. This refers to whether it is a Commonwealth or a state government power. We have exclusive powers. These are specific powers that are written into the they're powers by the Commonwealth, and only the Commonwealth can legally make laws in these areas. You'll need to know an example, such as currency or an army. Also written into the Constitution are the concurrent powers. These are specific powers that are written in the Constitution in these areas. For example, taxes and marriage. This is where Section 109 will apply on the next slide. Lastly, there are residual powers. These are not written in the Constitution. Remember, the Constitution was written in 1901. So not all of these current issues were thought of to be included. Anything that has been left out of the Constitution is not the state's power. Only the states can make laws in these areas, technically. Remember, we also have treaties and different things where we will see the Commonwealth impede on these residual powers. So just be careful about saying that as a definitive statement, that usually the states make laws in these areas with some exceptions. For example, our Victorian criminal law and our Victorian road rules would be examples of residual powers, along with healthcare and education as well. What about Section 109 of the Constitution? This is with an example. So what happens when both the state and the Commonwealth make laws in an area and they contradict one another, or they're in conflict? We know that this is probably going to be an issue because we have concurrent powers. So we have Section 109, and under Section 109 of the Constitution, if there is a conflict between the state and the Commonwealth laws, the Commonwealth law will prevail. This will mean that the inconsistent part of the state legislation will need to be removed or declared invalid. However, this does not automatically apply. The law must be challenged in the courts for Section 109 to apply. Why do we have Section 109? It is to ensure consistent and practical laws in this country. It's not possible to be able to follow two conflicting laws. What is an example of this? An area of concurrent law-making. Well, there was an inconsistency created. Sorry, we had a bit of a glitch there. So there was an inconsistency created in an area of concurrent law in relation to marital status. We had the case study of McBain v. Victoria. Now, what happened was the courts found that the requirements of the Infertility Treatment Act 1995 in Victoria were invalid because this new act in Victoria actually contradicted against the Sex Discrimination Act, which was 1984, and it was a Commonwealth law. Now, the Infertility Act said that a woman receiving IVF must be married and living with her husband. Well, the older and Commonwealth law, which was the Sex Discrimination Act, said it is unlawful to refuse service based on sex, sexual orientation, or marital status. Essentially, Dr. McBain was in real conflict here. There was a woman named Lisa Meldrum who he used as part of his claim, and Lisa was a woman in a same-sex relationship. Now, if he was to give Lisa IVF under the Infertility Treatment Act, he would commit a crime because he's not allowed to give this to Lisa because she was not married or living with a husband. Yet, if he said to Lisa, sorry, I can't give you this service, he would be discriminating against her based on her sexual orientation and her marital status. And yet again, he would be breaking the law. What McBain had to do was he needed to challenge this and take it to the courts. It didn't automatically kick in. The result? Well, the clause about being married and living with a husband had to be removed from the Infertility Act. Not the whole Infertility Act is destroyed because there are valid pieces of that legislation that are needed, but the part which discriminated against women being unmarried or in a same-sex relationship were removed. Another thing that you'll get asked to do is to talk about the checks on parliamentary lawmaking powers. Now, these questions are often wordy, but if you just stop and know that there are 5 checks and go through them carefully, then you'll be able to answer any question. A check. What is it asking you to look at? Well, power must never be trusted without a check. And any government without separation of powers, essentially, this is put in place to ensure the government is held accountable and that there are some limits or restrictions on their lawmaking powers. Because we have a concept where the absolute power corrupts absolutely. And to avoid that, we need to be able to scrutinise or check our parliamentary lawmaking powers. There are 5 checks that we can go through to ensure that our parliament are effective, trustworthy lawmakers. These are the bicameral structure of Parliament, the separation of powers, the express protection of rights, the High Court and their use of interpretation, and having double majority referendums. All of these in their own right check, restrict, limit, or protect parliamentary lawmaking power. Let's look carefully at the bicameral structure. The bicameral structure is a structure where there are 2 houses designed to check or scrutinise lawmaking. We know the Senate in particular is a house of review. The Senate must review bills passed by the House of Representatives. By doing this, a broad range of views is considered when scrutinising the legislation. Now, there are different scenarios which could occur, which could impact on the effectiveness of this check. Firstly, there might be a hostile Senate. This is a situation where the government does not hold majority of seats in the upper house, and they must rely on support of the opposition or independents to have their bills passed. Alternatively, we have the opposite scenario, which is rubber stamping. This is a term used to describe a situation where the upper house of Parliament automatically approves decisions from the lower house because the government do have majority of seats in both houses. Neither is a great situation. You'll also need to be able to discuss or evaluate the effectiveness of each of these checks. As such, you'll need to be able to talk about the strengths and the weaknesses. What are the strengths of a bicameral system? Well, it allows for review of legislation. It allows for considerable debate. Even if we have a hostile Senate, this could lead to a more careful and thorough review. Also, our bicameral structure is in the Constitution and cannot be removed. But there are weaknesses. If we do have a party that has majority of seats in both houses, rubber stamping could lead to a lack of review, with parties voting on party lines. Also, by having 2 houses, lawmaking is stalled at times due to ongoing and repetitive debates. Also, as I said before, voting along party lines may happen. This is where politicians don't vote for what the people or the states want and rather vote with what they believe their party wants them to do, such as Liberal or Labor. Our second check is the separation of powers. This is different to the division of lawmaking powers, so don't get the 2 terms confused. The Australian Constitution establishes 3 separate types of powers which operate independently of each other. That's a good definition to learn. This ensures that no one body makes, administers, and rules on the law. These are executive powers. This is the power to administer the laws and manage the business of the government. This power is held by the Governor-General, the Prime Minister, and his cabinet ministers. This slightly overlaps with the legislative powers, which is the power to make the laws. This law resides with Parliament, specifically the Senate and the House of Representatives. Remember, the Prime Minister and his cabinet ministers all hold seats within Parliament. As such, they are also part of these debates. Lastly, but separately, we have judicial power. This is the power to enforce and rule on the law. This power is given to the courts and tribunals to apply the law to various disputes. What are the strengths? Well, the judiciary are completely independent of the Parliament. We also have the executive, who are scrutinised during question time. And lastly, like the bicameral system, the separation of powers is outlined in the Constitution and cannot be removed unless with a referendum. Some of the weaknesses include that the legislative and the executive do combine and overlap in some ways. Also, judges are actually appointed by the executive. So the Prime Minister and his cabinet ministers do have things to say with judges' appointments to the High Courts. This could be seen as a conflict of interest. Check 3. Express protection of rights. This is probably the easiest one to outline. We have rights which are specifically listed in the Constitution. These rights can only be changed by referendum. What about all of our other rights? Well, our other rights are only common law, and common law can be abolished at any time by Parliament. So what are the 5 rights that you and I actually have that are protected by the Constitution? 1. The right to religious freedom. 2. The right to interstate trade and commerce. 3. The right to receive just terms for property acquired by the government, meaning compensation for land taken off you by the government. 4. The right to trial by jury. And lastly, the right to not be discriminated against based on the state where you reside. Now, strengths. These 5 rights cannot be removed by Parliament. Also a strength, the High Court will protect these rights if infringed. So if the Commonwealth Parliament do make a law that infringes on any of these 5 points, the High Court can hear the case and declare it ultra vires, which means beyond their power. These 5 rights limits Parliament's lawmaking areas in each of these topics. What are the weaknesses? Well, the weakness is that these rights can only be changed by referendum, and there aren't very many of them, and they're not necessarily the rights that you or I would probably put first on the list of rights we would like protected. Now, it also doesn't stop Parliament from making laws in these areas and infringing on our rights. They could really pass whatever they would like, and then it's up to us to challenge it in the High Court. So it is a little bit of a challenging system there. Check number 4, the role of the High Court in interpreting the Constitution. So make sure you're able to explain that the High Court protects us through interpretation of the Constitution. Now, the High Court was established under Section 71 of the Constitution. Under Section 76, the High Court is granted the jurisdiction to hear disputes arising from the Constitution or involving its interpretation. Now, what is the role of the High Court? Firstly, the High Court acts as a guardian of the Constitution. It is their role to explain what the Constitution means and how it should be interpreted, particularly in relation to those rights we spoke about before. 2, the role of the High Court is to act as a check on abuse of power. So if the Commonwealth has made a law beyond its power, the people can bring this matter to the High Court to declare it ultra vires. So this is a method for us to be able to stand up against abuse of power. Lastly, it is the role of the High Court to give meaning to the words in the Constitution. In many places within the Constitution, we have additional rights. Unlike the 5 rights we spoke about before, we do have what's called implied rights through the process of interpreting the Constitution. For instance, think back to the Roach case. Some of the key words that you will need to be comfortable with and use when discussing this area include jurisdiction. So this is a lawful authority to decide on legal cases. Ultra vires, which means beyond the law-making powers, and implied rights. Again, you'll need to know the strengths and weaknesses of High Court interpretation. So a strength, judges are supposedly independent. And by having the High Court, unconstitutional laws can be overturned. It is also an independent check because remember, we had that separate judicial arm of lawmaking. But there are weaknesses to this system. Judges can only rule on cases before them. So someone has to challenge the High Court if they believe the Constitution is being breached somewhere. These types of cases are particularly expensive and quite complicated as well. Lastly, the High Court cannot change the wording. They can only interpret it. So they have to be restricted by the terms and the words actually used during the construction of the Constitution. Lastly, our final check is the double majority referendum. Our Constitution can only be changed by referendum. In a referendum, people are required to vote yes or no to a proposed change to our Constitution. To pass, a double majority provision must be satisfied. This means that a majority of voters in the whole of Australia must vote yes. And that also majority of voters in majority of the states must vote yes. So we have 6 states, meaning 4 of those states must vote yes for this to get through. A referendum is a compulsory vote, meaning that all Australian citizens above 18 must vote on a proposed change. What are the strengths? Well, this is good because it allows for public, the Australian public, to refuse or accept change. It's not up to the Prime Minister or the government of the day. The vote is compulsory. So we know that people may sometimes be hesitant to vote, may not know what they're voting for, find it really boring to listen to the politics, but the vote is compulsory. So it does force people to participate. It also protects the state interests because even if majority of Australia say yes, unless majority of the states vote yes, it's not going to get through. However, referendums have some weaknesses. They can be quite complex and very difficult to achieve the double majority vote. It's also quite timely and costly. So there are very few referendums and most importantly, very few referendums that have been successful in this country. There are particular cases that you will need to know to outline some of the key points going forward. I advise that you maybe do like a little summary sheet like that will appear at the end of this PowerPoint to help you keep all this information in check. So, whatever information you have, your case must match appropriately. So let's work on that together now. You must know the significance of one High Court case. And in that case, that Section 7 and 24 of the Constitution were interpreted. Now, interpretation gives meaning to the words in the Constitution and declares any laws invalid that infringe upon the democratic principles of the Constitution. We have 2 sections in particular. Firstly, Section 7, which says that the Senate shall be composed of senators for each state, and that these senators are directly chosen by the people of the state. Similarly, in section 24, the House of Representatives shall be composed of members directly chosen by the people of the Commonwealth. Important consequences of this interpretation. Well, we have a recognised implied right to freedom of political communication. And also, it defines a person's ability to vote in Commonwealth elections, and that this right can or cannot be removed under certain circumstances. We will look at the case of Roach v. the AEC 2007. So, when answering a case study, it's important that you use this type of structure to help you answer the question in a coherent way. So what is the question of law being unpacked? What was the ruling? What were the facts of the case or the particulars? What's the result? And what is the legal significance of this case? If you follow this structure, it would be more effective. Let's have a look together. Roach v. the AEC. In this case, it was whether the Commonwealth Parliament could pass legislation that prohibited convicted and sentenced prisoners from voting in elections. The Commonwealth passed the Electoral and Referendum Amendment, the Electoral Integrity and Other Measures Act in 2006. And this prohibited all convicted and sentenced prisoners from voting in their elections. Wow. At the time, Vicky Lee Roach was serving a 6-year term of imprisonment. She had eligibility for parole in August 2008. Ms. Roach's case questioned the constitutional validity of the 2006 Act and the validity of further legislation passed in 2004. The 2006 Act prohibited all prisoners who were serving a sentence of imprisonment for a Commonwealth, state or territory offence from voting in federal elections. Before the 2006 amendment, only prisoners serving a sentence of 3 years or longer were excluded from electoral rolls. Ms. Roach challenged the constitutional validity of this 2006 amendment. What was the result? Well, the High Court, in a 4-2 majority vote, so there were obviously 6 judges, 4 went one way and 2 went the other way, held that the 2006 Amendment Act, which imposed a complete ban on voting rights for all prisoners, was actually invalid and unconstitutional. They relied on a number of sections of the Constitution to support this, namely Section 7 and 24. They protected the right to vote, as they state that it is a requirement that Parliament must be chosen, and quote, directly by the people. Thus, the 2006 amendment was declared invalid. However, there were stipulations, including the seriousness of the crime, as well as removing the right to vote for prisoners serving more than 3 years, that needed to be considered. Vicky Lee Roach was actually serving a sentence of more than 3 years, and even though she won her legal point, she was not actually able to vote in the 2007 election. Well, what is the main significance of this? This is the part that the assessors are looking for. The decision of the court affirmed that there is a constitutional right to vote for adult members of the Australian community, which is protected by the structure of representative government. The High Court did not go so far as to call it an implied right to vote. Instead, that this right is a reflection of structural protection. This representative government can act as a limit on the powers of the Commonwealth Parliament. The Commonwealth Parliament cannot legislate away a person's right to vote without a good reason. And just skipping back. You'll also need to note the significance of one referendum in which the Australian people have protected or changed the Australian Constitution. Section 128 outlines the process of changing the words of the Constitution. A compulsory yes-no vote is called a referendum, which we already know. You must achieve double majority, and once done, must receive royal assent from the Governor-General. The referendum that you could talk about is the 1967 Aboriginal People's Referendum. I'll find the slide to discuss that in more detail in a second. Now, what are the strengths? Well, elected lawmakers are not able to amend the Constitution alone. Is it up to the voters who can approve or veto the change? We know double majority protects the state interests, and we can ensure Commonwealth power is not increased without approval. Our negatives. The voters cannot initiate constitutional change. This lies with Parliament, so we can't call a referendum. Parliament do that. Out of 44 referendums in this country, only 8 have ever been successful. And there is a big question out there about whether Australian people understand constitutional change. We'll come back to that example in just a moment. So, the significance of one referendum in protecting or changing the Australian Constitution. We can use the 1967 Aboriginal People's Referendum. The issue. Essentially, we wanted to change the Constitution to allow the Commonwealth the legal right to legislate on Indigenous issues and that Indigenous peoples be counted in future census figures. Section 51 said the Commonwealth has the power to make laws other than the Aboriginal race. And in section 127, it also said in the reckoning of the numbers of Australian people, Aboriginal peoples should not be counted. Wow. We wanted to change this. We obviously wanted to amend that section 51 and cross out that bit about the Aboriginal race not being able to be included in Commonwealth legislation. And for section 127, we needed to abolish that one completely. We actually acquired double majority. So majority of Australia and majority of the states, so 4 to 6, voted in favour of making these changes, which was to amend section 51 and to remove section 127. This referendum was successful because it had bipartisan support, which means both parties on both sides of Parliament, Labor and Liberal, were both in support of this change. Why is this really important? Well, it allowed the Commonwealth to legislate on behalf of Aboriginal people to benefit them, for example, the Native Title Act. And it also aimed to heal some of the wounds of past discrimination and create a more equal Australia by removing some discriminatory parts of our Constitution. There was actually a 91% yes vote, and all of the 6 states voted, having a successful referendum. Let's go back a little bit. I know these slides kind of jump back and forth to one of our other key points. You must be able to describe the significance of one High Court case which had an impact of division of constitutional lawmaking powers. Again, you need to rehearse what the KK point is asking. So, significance of one High Court case, division of constitutional lawmaking powers. Then you can rehearse the case. So the High Court acts as a guardian of the Commonwealth Constitution, and it determines if legislation is within the lawmaking powers of the Commonwealth or the states. Interpretation on certain cases can change the division of power between the state and the Commonwealth. What are the strengths of this? Well, it's great because it acts as a guardian of the Constitution. and it can ensure that we have more consistent laws across Australia. However, there are some negatives. The courts cannot initiate a change in division of powers. They must wait for the validity of the legislation to be challenged by an individual, and then they must wait for that case to come before them before they make a ruling. Again, they cannot alter the words of the Constitution, but only apply meaning. The case that you would align this with is the RV Brislan case. And again, you want to try to work through the 5 concepts of what is the question, the ruling, the particulars, result, and the impact. So the question in Brislan's case is whether the term other like services, including wireless radio sets or a radio. The term other like services, was this a radio or not? Because Brislan had been given a fine for possessing a wireless radio without a registered permit. So if the Commonwealth can legislate in this area, the law is valid and Brislan should be fined for having a like service. If not, then the Commonwealth may be able to legislate in this area. Perhaps they can't. The law would be invalid. So Section 51 gave the Commonwealth Parliament power to legislate on postal, telegraphic, telephone, and other like services. When Brislan was charged with not holding a licence for her wireless set under the Wireless Telegraphy Act 1905, she challenged the fact that a wireless set was not mentioned in the Constitution specifically. The High Court then decided that the term other like services in Section 51 could include a wireless set, and they interpreted like services to mean wireless set. What was the impact? Well, this confirmed and extended the Commonwealth Parliament's power to legislate regarding wireless sets and clarified the meaning of Section 51. Lastly, you may be asked to discuss the impact of international declarations and treaties on the interpretation of external affairs powers. So the Australian government, our federal government, the Commonwealth government, regularly enters into agreements with other nations on a range of topics using their external affairs powers. They may sign a treaty. So a government signs an international treaty, for example, to protect the natural environment. Perhaps it's on climate change. And the government then, once they've signed that treaty, would come home to Australia and pass legislation to enforce that treaty in Australia, essentially to keep that promise to the international community. For example, we passed the World Heritage Properties Conservation Act. Now, what if the area that they want to legislate in is not an exclusive or concurrent power of the Commonwealth? Well, the Parliament will have the power to make laws for the peace, order and good government of the Commonwealth with respect to external affairs. This means that they can essentially rule in residual powers as long as it is for peace, order and good government. Now, what are the points to consider in this area? The validity of the legislation has been questioned many times, as the Commonwealth then infringes on residual powers. Is this fair? Well, in some ways it's a necessity. The Commonwealth is able to give effect to signed treaties, but the legislation must reflect the content of the treaty. So they can't go making laws outside of the international treaty they've signed. And the High Court must decide on a case-by-case basis by interpreting the phrase external affairs if their new legislations are constitutionally valid. One example that you could use is the Commonwealth v Tasmania case, also known as Tasmanian Dam, or known as the Franklin Dam as well. Any of them are fine. The question in the Franklin Dam case was whether the Commonwealth Parliament can use the external affairs power to legislate in an area of residual power. In this case, was the World Heritage Properties Conservation Act passed in 1982 valid? We knew that Section 51 gives the Commonwealth Parliament the power to legislate in regards to external affairs. And in this case, the Commonwealth Parliament used its external affairs power to stop the Tasmanian government damming the Referendum River and declared a World Heritage Site. Now, Tasmania were clearly not very happy about this. The High Court held that the external affairs power enabled the Commonwealth Parliament to legislate in areas of residual powers when enacting obligations under an international treaty. Therefore, the Commonwealth Act and the Tasmanian Act were inconsistent with each other. They then applied Section 109, and that the Commonwealth Act prevailed and the Tasmanian Act was inoperable as far as the construction of the dam was concerned. Essentially, the impact of this is that through external affairs powers, this increased the law-making power of the Commonwealth at the expense of the states. Here is a handy table to help you and help you with firstly what the KK point is and then answering that question in a logical way from the issue to the law, the facts, the decision and the significance. I strongly suggest that you print a hard copy of that and start revising some of the key terms in there. This was not included on the 2020 exam, but it will be included in the 2021 study design. So make sure that you are across this. So that's it for area of study 1. Make sure you do lots of practice questions on this topic, and most importantly that you try to include as much of the vocab that we went through today as possible.